Yes, Mr. Cavara.
Three short leftovers before moving to issue 2, if I may. First is Europhone. This is simply for information. Europhone International versus Frontel is referred to by the learned judge below at para 105.
Yeah.
Entirely my fault, but it didn't get into the bundle. And just to explain his lordship's comment, we've now laid it on the table, and hopefully it will find its way into the back of authorities bundle 8, just as
bundle 8.
No, it's not in bundle 8 yet. It should be just loose with a paper.
But it should go into it.
But it should indeed, in due course.
Mm-hmm.
And it's I'll tell the story in a second. It's para 35 of the Europhone, Mr. Justice Ferris, that is quoted by Mr. Justice Mann at 105 of Mr. Justice Mann's judgment. A simple story, again, interesting because there's a sort of malfunction, but a very different kind. A customer who had not been paying its bills was asking, or its liquidators were asking for VAT invoices from a disgruntled supplier so that they, the customer, could get the money from HMRC. The disgruntled supplier said no. And the customer brought a contract for an action for breach of contract in front of Mr. Justice Ferris, which it lost. In the course of his judgment, very much as an aside, and there's no suggestion that his lordship heard any argument on the point, but in the course of the judgment, he says what he says at para 35, which is page 8 of the printout, and it's simply one. So within para 35, well, perhaps if your lordship could read, it's going to be fast if you just read it and just see the aside.
So this is in the course of rejecting an argument about an implied term.
Yes, yes, exactly right.
The words are bringing into existence an obligation to issue VAT invoices.
Yes.
I don't quite understand how that fits with the quotation from Lord Donaldson. Self-interest, I understand, because as Lord Donaldson says, if the carrot's sufficiently delicious, you don't need the contractual stick. So that's you do it because it's...
Yes.
But,
and that's how the system works most of the time.
All right.
I mean, it's an aside. It has got no analytical hinterland to it. It's a comment, and it was referred to by the judge below. I don't make anything of it other than a casual remark by a learned judge. So that's the first of my three leftovers. The second is to say, because it's not readily apparent from the papers before you, that the writs, there's a cluster of writs here. There was a first wave of I'm coming really to issue 2 now. First wave in 2015. So the shadow there is 6 years back to 2009. And the second wave of writs, second cluster.
Claim forms, I think.
Claim forms.
These days?
So sorry, show my age.
It's a long time since people issued writs.
So the first series of claim forms was in 2015?
2015. I don't have precise dates, but I don't think you need them. And the second wave of claim forms was in 2017.
Right.
So the shadow goes back to, so-called 6-year shadow goes back to 2011. I mentioned that, A, because it's not unimportant to know it. B, that in a sense, the turbulence starts with 2009 and the ponderous process of turning the tanker, that is the Royal Mail, and its systems. And I'm told, unquantified, that there are even now a few pockets in the country where elderly franking machines, usually in the service of local authorities, still do not generate VAT-bearing bills. But no doubt these are highly exceptional. But the real point is there's a lot of action which happens within the 6-year period. I don't want to undermine my own arguments because naturally I'm asking for more on issue 2. But there's plenty going on in that period to merit, but only, of course, if you're persuaded on issue 1. So I now come to issue.
Just before you do,
Yeah.
I just want to be clear, because I'm not entirely clear, about what is the content of the duty that you say arises or is imposed on a private citizen who is a taxable person for the purposes of VAT. And you locate the source of the duty in domestic statute. Is that right?
I locate the duty in Regulation 13. Yes.
Regulation 13. And we are looking for an intention to impute to Parliament, not to the Commission or the EU or anything else, Parliament. So Parliament has an intention to impose upon a taxable person an obligation to issue a VAT invoice if and when it becomes apparent that such an invoice should have been issued, or at the time when the supply is made. Well, I just want to know what...
Yes,
because until this morning, I hadn't really appreciated that your case was either that there was no duty, alternatively that there was a defence of reasonable excuse, until some as yet indeterminate point after the court's decision in TNT. I hadn't understood that. So there's no obligation, or if there is an obligation, there's a defence. At least up until TNT. So throughout the 80s and the 90s, there's nothing that Royal Mail did that was, quote, wrong.
Yes.
So the duty, the obligation which we are to hold that Parliament intended to impose was a duty arising at some indeterminate point in the future, if and when it... No, I would like you, please,
absolutely.
I
see
exactly what the duty is.
And my self-imposed...
I mean, if you want to do this, put it in writing tomorrow morning, that's fine. But before we finally leave issue 1, I just need to be absolutely clear in my own mind what the duty is.
Well, may I, as it were, accept all invitations? So I'll fire from the hip now, but if I can then reflect,
yeah,
and if I need to, well, put it down in writing. It might be slightly different in the morning. With hindsight, I don't know. But my self-imposed approach is it's got to be kept simple, and it's got to be kept clear, and it's got to be kept in line with Regulation 13. So behind Regulation 13, you had all my elaborate submissions about direct effects and so on. But at the end of the day, the sharp end in terms of a British trader is Regulation 13.
Yeah.
So
that's quite clear, though, isn't it? That's 30 days.
Well, that is, number one, that is to issue the tax invoice, yeah, and to issue it, number 2, within a certain time frame. And I guess we're moving to the debate about, well, what's the position on day 31? We have that debate in the context of issue 2, continuing duty / when is damage suffered?
Well, yes and no. That's what I had thought before this morning. But if there is no duty on day 31, because TNT hasn't yet been decided, then we're having a different debate.
Well,
which isn't the debate, I must say, that I was expecting when I read the papers. But if there is no duty until sometime in 2009, 10, we don't know quite, I begin to get a bit fuzzy here, because if the duty was comply with Regulation 13 or else, I can understand that, in which case you would say, well, in 1978, or whatever it was, Royal Mail supplied this service. They should have provided an invoice, which they didn't. Therefore, they were in breach. Therefore, there was a private law cause of action, and then we can worry about limitation and loss and all the rest of it. But that's not how you put it this morning. You say, well, in 1978, when they supplied this service, either they didn't have an obligation to issue an invoice, or if they did, they had a reasonable excuse for not doing it. And you again, I hadn't appreciated this until this morning, you say that the reasonable excuse is, so to speak, part of the duty. At least the duty is not broken if there was a reasonable excuse for not providing the invoice. So we've got a situation, getting to a situation where the taxable person had a defence or wasn't in breach. That defence has been removed by a decision of the CJEU, or a duty has come into existence, but we've got to locate the source of a duty somewhere in the UK Parliament.
Indeed. No, I see these nuances. Just to, as I say, respond now, but then to reflect, if I may, and with the benefit of the transcript, no doubt. The duty is in Reg 13 and its predecessors, full stop. That is an always-on duty.
And always?
It's always on. It's a duty which is always on.
Yeah.
And if you find on day 35 that you have made a supply that you thought wasn't taxable, or you thought you were still under the registration threshold, for example, to go off on it, and then you discover later that you were over the registration threshold, so you've got to revisit all you've done, then you must do it. And it's no answer to say, well, I only discovered that I was over the registration threshold on day 40. You've got to go back and do it. And therefore, the time limit is to give encouragement to do it, but if you don't do it, you've still got to do it as soon as you find out that you should have done it. I'll make that more elegantly put in writing. However, we've been very anxious not to take an unreasonable position, particularly given seeking mandatory injunction. The court's not going to do anything that's not equitable. And therefore, we have from the start, although I think I didn't do a very good job in the skeleton on this, conveying this, accepted that the reasonably diligent taxpayer, if I can wheel him or her onto the stage, is the yardstick by which one must judge these matters. And the reasonably diligent taxpayer, and indeed the reasonably diligent commissioners, wouldn't have known what
by taxpayer, you're talking about the Royal Mail.
I am indeed talking about the Royal Mail.
The supplier. Taxable person.
The reasonably diligent taxable supplier would not have known. So how to deal with that? Well, I've already said, as a matter of legal realism, it would be an extraordinary thing to try and achieve that they insure us all the way back. So we're not trying, we've never tried to achieve that. So the way we say it works is you've got your duty, it's always on, the 30 days doesn't get you off the hook. It just means you've broken it from then on, you're in breach, you can heal the breach by issuing the invoices and then everything is fine. You've done no damage by doing that because time doesn't run against your registered customer because they don't have a claim until they've got the invoice. So you can heal the breach at any day by giving the invoice. And although the duty remains, you will have a defence and therefore you will not be liable to the penalty, and indeed you will not be in breach of the duty, if there's a nuance there, I'm not sure there is, if you can show that you were behaving, you have a reasonable excuse, which I submit is the same as you behaved as a reasonably diligent taxpayer. So let me look at that and write it down properly and proffer that tomorrow.
And I think you're saying that until this yet to be determined date, sometime between 2009 and 2011, there was a reasonable excuse. It then ceased to be available, whereupon the always-on duty, as you describe it, required Royal Mail to go back and issue tax invoices as far back as it reasonably could.
Yes. And subject...
As well as, of course, for the future.
Indeed. And if we fail on issue 2, and we're confined to those periods from 09 or 11 through to the 15 or the 2017 groups of claim forms, we will be looking at a period when it was indeed known that taxable supplies were or could have been being made. The problem becomes a slightly becomes a different one, because Royal Mail said, well, there are many nuances in terms of where the boundary lies between a general postal service, which is exempt, and the more commercial end of what they now do. So, and one will, whatever the reason why an honest supplier has not issued a VAT invoice, there will always be some debate to be had. The question, well, there won't unless we succeed in some form on issue 1. There won't be a debate.
Yeah.
And in a way, we're in issue 2 already, because we're talking about. I've made my always on point, so I don't need to repeat that. So just to position this, so issue 2 was dealt with by the learned judge in paras, just for your note, 210 to 234. And we devote the whole of our second skeleton to it. I'm not going to open that. It could and should have been much shorter. But for any use you want to make of it, it's tab 5 of the first volume of the core bundle. I'm just going to refer, once I'm past the very first point, that is to say, the sub-issue in issue 2, is damage needed to start time running? So that's the point where the learned judge at 214, para 214, page 28 of the bundle.
I'm not sure that Mr. Herberg supports that part of it.
No, I wasn't going to be, he doesn't. I don't want to be
in
presumptuous.
preliminary discussions amongst ourselves, we are rather sceptical about it. But it's up to you what you want to
take
do about
it shortly.
All right, I'll take that hint. I didn't want to be presumptuous, because presumably your lordships will get a judgment on that. Although, actually, at that point, the rather full skeleton is hopefully helpful. So I will just do, I'll get into a helicopter mode on that. There are really four or five points only. As a threshold point, his lordship was, I submit, aware of the big point we make, which is issue 2 on assumptions. It's just not the right vehicle for this issue, because there are too many variables. And he didn't say it, but rather his striking out as he did on his own, despite the parties submitting he shouldn't, in effect was to cut the Gordian knot and say, look, we don't need to worry about damage, it's straight away. The answer is step 1 of 5. If one looks at phonographic, which we might as well open because I'll come back to it anyway, phonographic is in Authorities Volume 4 at Divider 16, Authorities 4, Divider 16, Vice-Chancellor. Just looking at it for the moment on the very narrow point of is damage necessary? And at para 18 of the judgment, which is 2901 of the report, para 18 of the judgment, 18 and 19, if you'd be kind enough just to have a look at that, particularly the last words of 19, that's the classic position. So, therefore, the prima facie rule, as my lords and my lady are well aware, is that in tort, damage is the gist. We're not talking about trespass or anything medieval here. So the primary position is that damage is the gist, and also
para 18, do you say?
I think I should have started at para 16, my lord. I apologise. Where there's a quote from Lord Hoffman in a shipping case in Hamburg, saying at G, there was a single cause of action which accrued to the persons who owned the cargo at the time when the negligent stowage caused it any significant damage. And the phrase significant damage resonates with Sefton, which we'll look at measurable. Yeah. So perhaps 16 is the better place, although last line of 19 is to the same effect. In the case of a single act not actionable per se, the cause of action arises when and as often as consequential damage occurs.
In the case of continuing wrong.
In the case of continuing wrong, and that's obviously the sense of my always-on point, but it's also an answer to Mr. Justice Mann's. His lordship said, you suffer damage for the first and perhaps only time when you send in that VAT return without the additional negative numbers, which you would have had to put in if you'd had the invoice. To which we respond, well, that is true, but it is true of every subsequent VAT return, which also doesn't have the negative numbers. Only they build, obviously, as the years pass. And this is the point, that the claim remains pristine. The capital value of the claim is never subject to limitation. Because of these rules that we've looked at, time does not run until you've had your VAT invoice. So I'm struggling.
Sorry, I'm getting confused here. Time does not run in the sense that the VAT legislation does not preclude you from deducting your input tax. When we speak about time not running,
it's ambiguous.
We must not confuse time under the VAT legislation and time under the Limitation Act, because time may be running under the Limitation Act, even though you would be entitled to deduct your input tax.
And my lord, that last point is what I'm up against in this issue. And I've also drifted into the later parts of the issue. Let me focus myself back on this very first point. So I've made my first point, which is by reference to phonographic. My second point is by reference to the authorities that the learned judge refers to, Ashby and White, which we have in the authorities bundle at tab 4, and I'm not necessarily asking your lordships to open that. Let me just tell you that it's a very early 17th century case about voting slips in an election, and it appears to be a case which is explicable because of some perceived proprietary interest in voting, but it is also a case of a misfeasance in public office, and that appears from Watkins, which I do invite you to open in volume 7, which is volume 7, tab 23, and it talks, so this is the Supreme Court, this is prison officers, but it's about misfeasance in public office, and at 23, para 23, so cutting out much material that is interesting but not material, Lord Bingham, sorry, forgive me. Lord Bingham at page 408 of the bundle, speaking of the misfeasance of public office cases, says at 23 that second sentence, proving of special damage has either been expressly recognised as an essential ingredient or it has been assumed. None of these cases, and no authority, judicial, academic, cited in the House, lends support to the proposition that the tort of misfeasance in public office is actionable per se. Ashby and White, as I have suggested, is not reliable authority for that proposition. And his lordship expresses reluctance to disturb the position. And he goes on into 24 and 25. So the prison officers had been in bad faith opening someone's letters, but there was no tangible damage. I cite this page 408, therefore, for the twin propositions set out at length in my skeleton. That A, Ashby is not relevant anyway because it's not breach of statutory duty, although, of course, one can see the analogy. And B, the Supreme Court has said that in misfeasance cases, damage is the gravamen. So those are two reasons for not going down this road. Additional responses are, number one, his lordship didn't identify anything special about our putative breach of statutory duty, which would lift the need for damage, and he expressed himself in terms which were unrestricted and therefore could be seized upon in other cases and deployed in any statutory, a breach of statutory duty context, which obviously would be deeply, potentially will cause a lot of uncertainty. And the other two cases, which are classic on this point, are Pickering and the Liverpool Daily and Cullen. Pickering is to be found in volume 5 at tab 15. Volume 5 at tab 15. This, as I recall, it was a case about not publicising parole hearings, mental health hearings. So, Pickering, 1991 case, and at 420 of the report, yes, at just very short passage between B and C, which is sidelined, I believe, from Lord Bridge. So I rely on that.
Yeah.
And then in Cullen, I think is the next bundle 6.
Cullen,
my lord, it's bundle 6, tab 21, and report pages. This is another custody. This is a custody case, and at report page 1779, para 41. The heading is "The Need to Prove Harm." So at 1779, sidelined passage, and also another sidelined passage at 1785, para 66. So there's extensive further material in the written skeleton. So that is where I propose to leave this first point, and I come therefore to the main point, and prime references in the judgment are para 216 read with para 222. But the bottom line, as it were, was the judge's view that damage was suffered when that first return went in. So I've made the point that that can also be said of subsequent returns, so there's no more to be said about that. And I can see that that may not be, in one sense, a complete answer. More importantly, one needs to focus on whether damage was done when that first return went in. This brings me back to this theme that things are perhaps factually too uncertain at this stage for this to be dealt with confidently, although the court can, of course, give, potentially, if it's so inclined, give guidance to the parties on this.
Well, what do you say about the judge's point on the quiet time at injunction?
Because
that seems, in the end, to be the driver behind his conclusion on this, that on day 31, you could get an injunction to compel the issue of an invoice.
Yes,
even though you're still within your prescribed accounting period and the time hasn't yet arrived for you to make your VAT return.
Yes, indeed. Well, in that sense, we don't disagree with him, because that's really the principal relief, as I've said today. That's the principal relief we seek, which is to get the injunction, whether it's quiet time for the future, although I think generally the thing is sorted now, subject to that one area perhaps.
But you would say that the court has the power to issue an injunction in anticipation of loss, not just in anticipation of breach.
Precisely. And I mean, it's the same.
And cause of action is not just breach. Breach plus loss.
Yes. So the quiet. So, and I think again, my memory may be at fault. I think Malone and I were united on this. He'll tell you later. But one could get that injunction, even as it were within that first period. Or if someone says, "We're about to do this construction job for you, but we won't be sending you a VAT invoice at the end." One could, if a court is there available to be moved, one could move the court and say, "This is an imminent breach, which will cause loss, but it may or may not cause loss, but it's an imminent breach, and it's an unlawful act, and it needs to be restrained." Which will be quiet time if it's ahead of time, and a mandatory injunction to terminate a pre-existing situation of breach, or a combination of the two, depending on when in the story and what the story is. So my Lord directed my attention to that, which is, of course, a situation where, subject to the UB Tiger point, which is to come, would not. Well, we will be submitting tomorrow in reply that Thursday that on the mandatory injunction and time bar point that. Subject to late fees and so on, such relief can be sought, irrespective of the Limitation Act. But that's the next episode, as it were. Coming back to the money claim, which is really what issue 2 is about, secondary though it is, it's still there, and looking at it from a number of aspects, and bearing in mind Sefton, to which I need to come in just a second. I say this. First of all, the capital value of the claim doesn't change. It's pristine, and therefore one is not It's not one of those cases like, for example, the solicitor negligence cases where a long-delayed personal injury claim becoming ever more amenable to a strikeout begins to lose its value for the purposes of assignment, and much thought is given to when the cracks in the asset's value became irreversible, and that's sort of Sefton territory. We don't have that problem in this case. The asset doesn't age, it doesn't change, it's simply there. It doesn't get better, it doesn't get worse. So capital value unchanged. Second point, running of time. Although the learned judge held that the loss is instantaneous, as soon as you've sent your return in, you've lost, quotes, the value. That's not right in the following sense, which I've already deployed, which is you've only lost the value if, but for sending in the return, you would have got the money. And that's where my point that the commissioners weren't going to be paying until the TNT phase of the story. So we could have sent in lots and lots of returns, but the commissioners would not have paid them.
Well, that doesn't help you, does it? Because if the commissioners had refused to pay you, you could, at any rate, have gone to the CJEU and said, look, the commissioners aren't paying me. They say this is a zero, an exempt supply, but it isn't. And the CJEU would say, you're quite right, it isn't.
Well, it may be that the tax tribunal, if we had an invoice, we could have done all of that in the tax tribunal. So, but I'm not disagreeing.
I'm talking about loss. You say even if you'd had an invoice, HMRC wouldn't have paid, therefore no loss. And I don't think that follows, because you would have said they're wrong. They should be paying. And I'll go to the FTT, and Judge Mosdale would have said, you're absolutely right.
Indeed. Perhaps the nuance was slightly different, because I can't dissent from that. And indeed, that's one of the points that Mr. Justice Mann made, that sooner or later you would have got your money. But we rather turn that round and say, well, that's the capital value point. We haven't lost out there. But I was on to the running of time. So I think of the time value of money.
Yeah.
Not that I believe and submit that the mere fact that you have an interest claim later down the track, under statutory interest or something, alters the moment when the loss arises. And just focusing on the moment when the loss arises in terms of the running of time, this is a cash flow point. If what I'm really saying is that we wouldn't have got our money then, and that's not Royal Mail's fault, because Royal Mail, on this hypothesis, they would have given us an invoice through gritted teeth or whatever, but they would have given us the invoice. But that wouldn't have turned into cash until a third party, who has the real purse strings, was likely to say, all right, we'll pay up. So it's a simple factual point. There's very little legal analysis in it. But Royal Mail are entitled to say, but we didn't cause your loss, because for 10 years, if we put in that 1997 tax invoice, you would not have got the money from the commissioners until 2007, whatever. And that's the point. It's a simple factual point, as to which there needs to be evidence.
So just to go back to the cause of action, you've got to have breach, causation, loss.
Precisely.
Now you're focusing on causation.
I am. I should have flagged it.
You say breach, yes, should have issued an invoice and they didn't. Causation, loss, no capital value loss. Could be a time value of money loss, but not caused by the breach.
Precisely.
Would have been caused by HMRC's refusal to pay.
Yes. So that's because, if I may put it crudely, Royal Mail, in a sense, is the cue ball. Here. They're caught in the middle.
You say that all those three elements come together at this indeterminate point in time after the court has ruled in TNT, when the position ought by then to have sunk in.
And that's what and it's a simple factual point that needs to be addressed.
So that means we can or can't decide it. I mean, on assumptions. I see what you say about.
I mean,
what do we do?
Your Lordships can repeat, if I may say so, in no disrespect, sort of basic textbook material about causation, but we'll all have to go away and just have the evidence of the witnesses.
So that would result in what? Simply setting aside the judge's order and leaving it for trial?
Well, indeed, or perhaps giving the guidance that what needs to be ascertained before you can reach a decision on this is, and my lord just went through the 3 stages. I won't repeat them back to him while I'm referring to the basic textbook stuff. Acknowledging the tripartite nature here, and that, in a sense, going back to the letter of credit, we get the documents from Royal Mail, but we present them to the commissioners, and we know the commissioners would not have been responding, and therefore we cannot lay the delay at the door of Royal Mail, actually, until a time either close to, or in some cases within, the 6 years. I must assume it's going to be outside as well, otherwise issue 2 has no function. And I would add, I have to establish the breach, and I've clarified the point which I made this morning, that the reasonable excuse. As it happens, reasonable excuse and the TNT point and the commissioner's softening attitude would probably have all come at roughly the same time, not quite at the same speed.
And it's only the time value of money that we're concerned with.
Only that.
Because if, as you say, your capital claim remains pristine, as you call it, then you never suffer the loss. And so the cause of action is not complete. So it can only be the time value of money that completes your cause of action.
Indeed. It's quite an extraordinary set of circumstances, this case, almost at every stage. But that's right. And then the further fact, which is, again, which I've made, which is the reasonable excuse point, which also means we can't necessarily prove a breach given the reasonable excuse point. So these are matters. That which your lordships could do would simply be, if persuaded, to clarify these points and to say this is too fact sensitive for this kind of assumptions-based approach.
Yes. Well, I'm reminded of Lord Scarman's observation in a case called Tilling and Whiteman about preliminary issues being treacherous shortcuts.
We've all lived through the dawning knowledge of that, how accurate that is. And I don't just mean this case, just generally.
As you point out, you still have the capital value of your claim, because you could still put in, if you had the invoice, you could still claim the input tax back.
Indeed.
And one day perhaps you will be able to.
To be seen, yes. So it just sits.
I take it that one of the, perhaps I shouldn't take anything for granted. Is it still uncertain as to which services are exempt and which are taxable?
Well, not in our minds, but but certainly there is a big debate.
It's not yet agreed.
Yeah. I mean, there may be, no doubt it'll be the usual story. There's a core that are clearly in, a core that are clearly out, and then the penumbral battle.
Who decides that? Is that for the tax tribunal to decide?
No, unfortunately not.
This is going to be something for the High Court.
This is Chancery Division. He's going to just retire, but I don't know who's going to do it. But again, it will have to be whoever hears the next tranche.
Right. Well, I mean, I saw from the judge's judgment that he invited HMRC to join the party and they refused. But presumably, if somebody's going to decide what is or isn't exempt, they might well change their mind.
Well, I think it would be very useful if they were present. Indeed.
Yeah.
So, in a sense, I've said it all. It might just be helpful for a brief moment to open Sefton, although it doesn't really add anything to what I've said. But if I can just detain you for 3 minutes, and then you've really got my submissions on
Yeah.
issue 2. Sefton is authorities 4, so it's bundle 4, tab 15, and it's a different scenario.
This is the solicitor compensation.
This is a solicitor compensation case, tab 15, volume 4. The issue there centred on the facts are quite different. In all cases, the facts are quite different from this case. But the issue there was that there was negligent accountant, or allegedly negligent accountant, not digging up the dishonest behaviour of the solicitor over a number of years. It all comes out. Law Society has to pay lots of money. They go after the accountant. And he says, no, you're time barred. And Lord Hoffman at 31, yes, Lord Hoffman at 3031, which is page 554, which I won't read aloud, but what he's dealing with there is situations where there's as it were, a sword of Damocles, which may or may not fall. And he says this is not a Forster and Uhtred case where the damage is pretty much instant. 31, where he says the fact that the liability is contingent doesn't mean damage has been suffered. And Lord Vance to same effect at 81 to 82. And perhaps just two other very short references. At page 550 of the report, Lord Hoffman quotes the High Court of Australia, taking a narrower view than Forster did. And at E, on 550, in the middle, there's a quote from the High Court of Australia. Rather, it seems to us that the decisions in cases which involve contingent loss were decisions which turned on the plaintiff sustaining measurable loss at an earlier time, quite apart from the contingent loss, which threatened at a later date. End of quote. And Lord Hoffman says at 18, I say at once that I am in complete agreement with this analysis, which provides the answer to this appeal. It's the lack of any measurable loss that was the key to the way that case came out. So, my lords,
is Law Society and Sefton the last word on the subject? I have a vague memory that there's been discussed in subsequent cases. I may be wrong.
Let me check. By the way, we've looked at Doe and Bridges.
Looked at?
Doe and Bridges, which my lord referred to. We can't understand it yet, but we'll look at it overnight. It's not that. So I'm most grateful. Those are my submissions on issues 1 and 2.
Yes, thank you.
I've got it.
My lord, my lady, can I start at the outset by picking up, before I come to my submissions, some of the points that arose out of my learned friend's submission, two of which are contextual, but the first one, to my apprehension at least, is potentially quite fundamental, because I share the surprise and slight puzzlement of Lord and Justice Lewison about the way the claim has been formulated in court today, which, as far as I understand it, was not the way it was put below, and potentially I think may affect analysis as to what is the claim and what is the breach, because the way in which the duty was formulated, building into the duty the reasonable excuse provision in Regulation 13 as part of the duty, switching on the duty, switching off the duty.
Reasonable excuse in section 69, I think. Is it
I'm
Regulation
section
13 as
69.
well?
Yes, I'm going to come to the two. It's
Yeah.
interlocking of Regulation 69 and Regulation 13. You're quite right, my lord, in Regulation 69. But by building that in to the duty itself, it potentially affects the analysis, and indeed, in our submission, affects strikes at the heart of the ability of the claimant to succeed on issue 1. Can I just go through, as I understand it, what was the way it was being put to the court?
It certainly affects issue 2.
Well, my lord, the analysis may be that the claimant can't succeed on issue 1 unless it succeeds on issue 2, because unless there is a switched-on duty always speaking in terms of issue 2, I find it very difficult to see how there can be a breach of statutory duty in the first place. Up to now, issue 1 has never been dependent on issue 2. It's been a self-standing ground. Issue 1 is there a breach of statutory duty? And then issue 2 is, well, if there is there a continuing duty? But there is a possibility that this reverses the picture.
I'm sorry, can I just go back? I don't think issue 1 is, was there a breach? I think issue 1 is, was there a duty?
Lord, yes. But
I mean, I take your point,
yes.
but as Mr. Cordara explained it just now, the cause of action is only ever complete in respect of the time loss of money. Never complete in respect of the capital value, which he says, of the claim, which he says remains quite pristine, unquote.
Well, Lord, that of course depends on there being, in a sense, I think a continuing duty.
Yes.
But we don't accept the time loss point in the first place. We say there was a time loss from the very beginning.
Yeah, anyway.
Because, of course, just to anticipate, if they pursued HMRC for the money at that stage with the VAT invoice in hand, and HMRC had wrongly said no, and it had trundled through the courts, and they'd be finally vindicated, they would no doubt have got an order compensating themselves for the time loss of the money right back to the beginning. So it's absolutely not right that there's no time loss claim from the beginning against Royal Mail, on the obverse hypothesis that Royal Mail didn't provide a VAT invoice, and so they weren't able to launch that action against HMRC and vindicate their right. They have a loss, a time loss, which is Royal Mail's fault in not providing the invoice from the very beginning. So the time loss point was an elegant attempt, but in my submission, it simply doesn't work. It's perhaps best, it comes at the end of the argument, but if one goes back to the beginning of the argument, it's a mirage. If one actually follows through the two hypotheses, if we give them an invoice and they ask Royal Mail for the money, and Royal Mail say, ask HMRC for the money, HMRC X hypothesis wrongly says no, they have to spend potentially years vindicating their right in Europe, or maybe not that far. When they succeed, they will no doubt get an order not only for the capital sum, but a compensatory order for HMRC wrongly having kept them out of their money for all that period. and it is that compensatory order, order which they are deprived of from the very beginning. When Royal Mail says, wrongly says, ex hypothesi, we won't give you an invoice, because they say, we don't agree, but they say, we couldn't go for our money without that magic piece of paper. Of course, we say, yes, you could, there's the discretion, there's everything else. But sticking with the assumptions of their case, there is a time loss from the very beginning.
Right.
But what I was just wanting to explore at the outset was the way that the duty is now formulated. What is said is that the duty to provide an invoice is subject to the Regulation 69(8) defence. Failure by any person to comply with the regulatory requirements, the requirement referred to in Section 2, shall not give rise to liability to a penalty if the person concerned satisfies that there's a reasonable excuse for the failure, and so on and so forth. And if it is then accepted that Royal Mail had a reasonable excuse by reason of all of the obscurity of the legislation, or the fact we weren't asked for it, the fact that everyone was under a common mistake, in fact, then there was on their case no breach of the duty until many years later. Potentially no duty until many years later, because it's not just breach of the duty. What he said is that we haven't actually got a duty to provide an invoice, as I understood the way it was formulated, until those conditions have been satisfied. If we have a reasonable excuse, then we don't have to provide an invoice, because the reasonable excuse is a Regulation 69 defence. If one plugs that into Regulation 13, which is the obligation to provide an invoice, the obligation is an obligation where we make a taxable supply in the United Kingdom to provide such persons, as I mentioned above, with a VAT invoice. But what Mann J has done, as I understand it for the first time, is to staple onto that apparently unqualified duty the defence to the penalty, to the civil penalty, which you suffer if you don't comply with the obligation. The civil penalty, which he incidentally says is the inadequate measure, which is not something the court should be too concerned with in looking at the statutory duty, because it's inadequate and because it doesn't go very far, and it's not a very good indication that Parliament didn't intend to impose a statutory duty. But what he's done by his formulation is actually to staple that civil penalty defence into the very heart of the duty itself, and means on the face of it that we would say that the duty disappears entirely, because what is the duty? It's a duty to provide a VAT invoice within 30 days, sub-regulation 5, within 30 days of the time when supply is treated as taking place under Section 6 of the Act. So our case, of course, is that the duty arises once and once only after 30 days. We have to provide an, or exists for those 30 days. We have to provide an invoice within those 30 days. If it's not provided within 30 days, there is a breach, and there are no new breaches thereafter. And if we're right on that, in other words, no continuing duty, a once-off duty, then on an defence formulation, it doesn't appear to be there can be any statutory duty at all, because on his case, there's a reasonable excuse defence stopping any duty arising on day 30. So there's no breach right back at the beginning. And we say no duty arises later. Years later, everyone appreciates that VAT was due. But at that stage, there is simply no duty, we say. There's no.
Well, I think he says that the duty that arises is a duty to provide an invoice either within 30 days or at the end of such period during which you have a reasonable excuse not to provide the invoice.
Well, that's not what we said. That's not what.
And I think
yes.
that's how it's got to be, in order to accommodate his. Because the reasonable excuse, he says, runs out.
Yes.
Sometime after TNT.
Yes.
Not because of any facts that have changed, but because the understanding of the law had changed.
Yes, my lord.
So that's way past the 30 days. And he says, well, there's a continuing obligation tempered by the reasonable excuse not to provide the invoice.
So, my lord, that is where it therefore appears to me that it's right to say that unless there is that, as it were, continually speaking duty sitting there underlying, capable of being switched on at any moment when the reasonable excuse disappears, then there's simply no breach of statutory duty whatsoever on the analysis. Yeah. Because, as we would say, we all realise years later, we then look at the obligation to provide an invoice. Well, it's to provide one within 30 days. Well, we weren't in breach of it then because there was a reasonable excuse, and there is no duty thereafter. There's nothing. There's no continuing duty that can be switched on later. All there is an obligation after 30 days to provide within 30 days to provide an invoice, and you've either breached it at the end of that time period or you haven't, and that is the end of it. Well,
and the different analysis, other than the continuing breach, is that when you strip away the defence, in effect, that is to create a retrospective duty.
Indeed, Millie.
And that makes it difficult to spell out.
It would an incredible retrospective duty, as we've seen, switching it on years or decades later. And of course, there would be, if one got into that, huge arguments about what one could then reasonably do in terms of practicality and what invoices one could reasonably one could reasonably expect to provide many years later. But the point is a much broader one than that. That interpretation of itself, we say, is extremely odd and artificial. But it's even more odd and artificial when it is considered against the background of a legislative scheme which actually provides alternative ways for dealing with this sort of problem. And that is, of course, the discretion of the commissioners to accept a claim for VAT repayment without a VAT invoice. And I'll obviously come on to that as one of the key indicators that we rely on in opposition to the statutory duty. But it's, of course, of huge significance that where one is doing this sort of archaeology, if I can put it that way, of working out what should have been done years before, what should have been paid, what should have been accounted, it is open for anyone in that case, or even in a case where you simply don't get an invoice because someone goes bust or for whatever reason, it is open to the trader to approach the revenue and seek payment without the evidence of an invoice.
So you say that the duty, bears on both, bears particularly on issue 1, but also on 2. The duty is to issue a tax invoice within 30 days, but that at all times up to some point after the decision in TNT, your clients would not have been subject to the sanction of a fine because you would have had a reasonable excuse, a perfect excuse, in fact,
Well, that must be right.
for not issuing the VAT invoice because no one thought you had to. No one at all thought you had to.
Including the revenue. The revenue had turned round and tried and imposed a penalty on us for something that they didn't themselves think we had to do.
So, and it matters nothing to that analysis for him to point out that if you were to produce, to provide a VAT invoice at a later date, even a much later date, his clients could still recover the input tax.
That doesn't go to whether there's a duty or not.
It doesn't go to whether there's a duty or not, or to when the duty was broken.
No. That's absolutely right.
No, I mean, whether there was a duty actionable by him is, of course, the fundamental question. we need to analyse what that duty is, which is why I think my lord.
Indeed, Lord. That's why I started with this point, because it does seem to me that this new way of stapling into the duty the reasonable excuse defence potentially changes the analysis, and we say to him, it gives him an additional difficulty, which I can see the reason why it might be seen to help, because the duty arises later, and that may help for other parts of the limitation argument. But the fundamental issue of what is this duty, one can then see, and one can then see that the duty arises once off. It is not complied with. Well, there's a question at that stage: is there a reasonable excuse, or isn't there a reasonable excuse? But that's the stage at which the duty, there's either a breach of duty or there's a one-off. And
I mean, there's also the question of retrospectivity, as my lady points out, and I did wonder whether some indication of parliamentary intention might be gleaned from the way in which the law was changed. It was changed, as I understand it, by Section 23 of the Finance Number 3 Act 2010, although I don't think that's in our bundle. And the change applied to supplies made on or after the 31st of January 2011. So one might perhaps infer from that Parliament did not intend any change in relation to supplies made before that date.
My Lord, indeed, I gratefully adopt that point. It is certainly another indication of. Lord, indeed, precisely your Lordship. I'm about to try and embellish your Lordship's point, but it speaks for itself. It is an indication. There is a forward-looking date on which the change is imposed, and that certainly is consistent, if not more than consistent, with not imposing a retrospective obligation. And in my respectful submission, a retrospective interpretation is not one that the court should be reaching for unless it is really impelled in any event on the statutory language. And there's absolutely nothing in the two regulations when one puts them together to suggest that there was any such intention. All of the indications which I'm going to put to the court and deal with, I hope, relatively briefly, are all, we say, indications against there being an intention to impose an actionable statutory duty. And it must be remembered that one is actually looking here for positive indications. It's an exceptional situation for a actionable statutory duty to arise. It's not the normal course of events. It's an exceptional situation which the courts derive from the patchwork of indications that we will come to. But it is noticeable here that there's nothing which even makes the case, we say, as a starting point, makes the case for that obligation being imposed in this case, in the language or in the way the provisions are structured. There is a slight artificiality here, because as your Lordships and Ladyship picked up, we're looking at regulations here, delegated legislations made by HMRC, but we're looking for the intention of Parliament.
It is HMRC that makes the regulation.
Yes, that's my understanding. That's why I'm nodding behind me at those who know more detail. It is HMRC. We're looking for the intention of Parliament, which can only come out of the primary legislation which empowered the regulations. Now, we can fetch out for the court tomorrow morning, I haven't got it to hand, the first page of the regulations, which sets out the powers under which they're made. Extremely unhelpfully, there's a huge long list of powers in the VAT legislation, and there's even some concluding words such as "and all other powers which the revenue possesses" or something like that. And it is impossible.
That'd be absolutely standard for a draftsman to put that in.
Well, it makes it completely impenetrable. I think we tried this exercise below, and we couldn't work out the particular power that matched up to this in any event.
Is it not the one in Section 25?
My Lord?
Is it not the one in Section 25 as a regulation power about how you make claims?
Well, I certainly don't say it isn't. It's just not. It's not clear. That certainly may fit. But what we would in any event say is that there's the claimants cannot point to any power, or any power from which it can be inferred, from which there's any indication that there was an intention to create an actionable statutory duty here. In a way, the point, my Lady Justice Asplin put the point as perhaps as best as it could be from a learned friend, that well, there's an EU obligation, and as it were, Parliament does the best it could to write it through into obligations under the regulations, and through the empowering legislation, as it were, the scheme is transferred through. We say that comes adrift or hits the rocks because there's no indication in the European legislation either, as I'll come on to the point in the directive, that member states were mandated to make a damages claim, an obligation in respect of this obligation. There's no indication whatsoever, and indeed the discretion given to member states as to how the duty to provide a VAT invoice should be applied is manifest in the way it's framed. So we say that gets them nowhere in any event.
But you might see, I don't know, but it might well be the case that different member states would have, for whatever cultural, political, whatever reasons, very different attitudes to whether individual taxable suppliers should be put under a duty actionable by their customers,
Yes.
which would be within the freedom of manoeuvre of member states implementing the directive.
Well, I accept that. So one could say, well, there's nothing in the European legislation mandating it, but actually, when you look at our primary legislation, there is here this clear indication that Parliament did intend it. It's not entitled to gold plate, and it's so clear that there is, for that reason, we can find an actionable statutory duty here. I accept that is in principle possible, but
if a member state chose to do it by primary legislation which authorises subordinate legislation to go into the detail, then Parliament has authorised the subordinate legislation that arises.
Indeed. Well, that again, I accept that's possible, provided the subordinate legislation isn't in some way ultra vires the primary legislation. That's a legitimate way of doing it.
What you say is that there isn't any indication, sufficient indication in what we've got.
In any of the levels. There's no sufficient indication in the EU legislation, there's no indication in the primary legislation, such as one can detect it, and there is no indication in the secondary legislation. So the reason I went back to the EU legislation is because it's used by my learned friend as an important part of the background and an important part of generating his actionable obligation. But we say it doesn't work at that level, but I wasn't suggesting that was the only level.
No.
I fully accept. We say that at none of those three levels is there any sufficient indication, or indication at all, and indeed all the indications point strongly in the opposite direction. Well, can I make two other preliminary points in response to matters Malone then raised, and they're rather more contextual. The first point is that Malone's friend showed you his table of the VAT effects of those transactions. That was a table that was an old friend for me. It was familiar because it was in evidence at the hearing below, and indeed there was considerable dispute on it. The point for present purposes is that the analysis is hotly disputed and certainly not accepted by Royal Mail that establishes that there are higher prices for customers, or that there's no windfall, or anything like that. And what I think best I can do is to show you how the judge dealt with this issue in the judgment at paragraphs 18 to 20. And he dealt with it in the context of a windfall. That was the context in which...
Well, he said it didn't really matter.
He said, it's not something I need to decide, but, he said...
Yeah, well, do you say it's anything we need to decide?
Lord, no, we don't. But what we do, but it's important because it does set the background. If one thinks of it in those terms and one has that in mind, it's something I do need.
He thought Lord Justice Henderson was a bit more on your side than on Mr.
He did. He says he confines himself to his own irrelevant observation that it is apparent from the judgment of Lord Justice Henderson in the Court of Appeal, this is para 20, in the Zipfit litigation, that his view of the economic merits seemed to coincide more with Mr. Herberg's than with Mr. Cordara's. Now, there was detailed argument about it there. This was the argument that effectively that it was an uncovenanted windfall, that it would offend the sense of fiscal justice of right-thinking taxpayers and so on, for this sort of claim to be permitted. It's not. It would be involved extremely detailed VAT arguments to even explain what the difference is between the two analyses, and there are all sorts of confounding features. But that's as far as I need to take it. It's not accepted that the transactions work themselves out in the way he presented, and that we do say that Mr. Justice Mann was right to say, as he noted that both sides accepted, that it didn't actually affect the legal argument. He said, yes, well, he said at 20, these points are not relevant to the questions I have to decide, which are technical and not merits-based or economics-based. I don't have to develop or consider them, and so on and so forth. But the other point, to somewhat similar effect, is the point he made that, well, in any event, Royal Mail is protected from a claim by HMRC if it issues the invoice. Why on earth aren't we doing what they want and just give them the invoices? We can just then gently fade out of the picture, and Mr. Cordara can take up the cudgels with the revenue and try his luck there on perhaps on a more favourable basis than zip fit. Well, once again, all I need to do on behalf of my client is just to point to the passage of the judgment where the judge certainly didn't accept that was necessarily the right analysis. He said at paragraph 164, whatever the customer might, and this was in the context of an argument about terms and implied terms into the contract in a slightly different context, but the point is made. He says Royal Mail would never say, of course, to a proposition that should imply into it an obligation to issue the invoice. The reason for that is that to agree to a render of VAT invoice of the kind required by Mr. Herberg would expose Royal Mail to financial risk and to upsetting the agreed commercial deal. If it rendered an invoice, it would be obliged, or at the very least be exposing itself to an obligation to render the relevant VAT to HMRC. Mr. Cordara sought to say that there was no longer a risk in this case because of the limitation period for liability contained in the VAT Act, Section 73, 1 to 4 years, meant that there was no exposure to liability in this case. Mr. Herberg sought to say that there was still a potential exposure under Schedule 11, which Mr. Cordara in turn disputed. I need not deal with the real effects of this legislation and therefore don't set it out. The fact is that Royal Mail will perceive a risk of a substantial liability, and it must be remembered that the questions we considered today, well, the perception is of course the question of which went to the contractual.
Yes, but he's looking at it as at the date of the contract.
Well, he is.
We've got assumption 8, haven't we?
Yeah.
HMRC has no recourse to claim the VAT, including the consideration price from Royal Mail.
This is the danger of reading assumptions in the abstract. That was not what that assumption was dealing with. This is an important point which I should deal with at the outset. The assumptions 7 to 9 were purely assumptions which were directed to a restitutionary claim, which was originally down to be decided on preliminary issues, but all parties realised that there was a step too far, that there were assumptions that were needed, that the restitutionary claim couldn't be judged without more facts, and so they were withdrawn before the action started. If you look at paragraph 30 of the judgment,
Yeah, I see.
last 3 assumptions were relevant only to the restitution claims which have been taken out
So
of the
should we strike out those assumptions for the purpose of these issues?
Lord, yes.
Otherwise it gets a bit confusing.
Yes, and indeed it makes very little sense. The claimants are unable to recover the VAT included in the consideration price from HMRC or any other party. Well, then what's their claim against Royal Mail? If they couldn't recover, then there's no point in having the invoices. There's no claim at all. There's no damage. So it wouldn't make any sense to apply that assumption more widely. It was an assumption which was particularly designed for the obverse situation where they're seeking to make a restitution, there's a restitutionary claim for the money and they're claiming against revenue without an invoice. Yeah. It's a completely different. And it was a step too far. It was the judge below more than once repeated to himself and to counsel using the cautions about preliminary issues. And to be fair to the judge, spent some while in advance at case management conferences seeking to road test them and to work out what was needed, what assumptions, what background facts, and was very alive to the perils, and we had more than one debate on the subject. In spite of that, by the time we got to the trial, we ran into problems on restitution and that's a bit. But we do say that for the other issues, the issues which were decided by the judge and now before this court, the assumptions have worked and have enabled useful work to be done, as he put it, in testing what would otherwise potentially have been strikeouts in relation to limitation and continuing duty. But can I then come on to the legal principles to be applied? And I'm take this very shortly, and I don't need to go back through the authorities that Mr. Cordaro has taken the court to this afternoon. The parties, as we said in our skeleton at paragraph 13, were agreed that the test to be applied in assessing whether Parliament intended to confer a private law cause of action for breach of a duty imposed by legislation was the Ex and Bedfordshire test. And although there were some indications in the skeleton perhaps challenging that, Mr. Cordaro has obviously taken up that line again today, and effectively the parties are agreed on at least the test set out in Ex and Bedfordshire. In their skeleton argument, they purport, as they put it, to distinguish Ex and Bedfordshire and Ex parte Hague in principle on a number of grounds, as they put it in paragraph 34. But as we understand it, they're not really seeking to distinguish those cases in principle. They are pointing to facts or considerations which they say are different in those decisions from the position before this court. The first factual point they make at paragraph 34 of their skeleton argument is that in neither Ex and Bedfordshire nor in Ex parte Hague was there any question of a duty to construe the domestic legislation in conformity with EU legislation. We say that's true but irrelevant. An interpretation of the domestic legislation which does not give rise to an actionable statutory duty is clearly fully in conformity with the EU legislation, which does not require any duty to be actionable at the suit of a private person. Indeed, we say...
Can I just make sure I've understood that? I thought from your skeleton argument you were saying it was relevant because you shouldn't assume that Parliament meant to go beyond what was necessary to comply with EU legislation. You just said it's irrelevant.
No, sorry, I was about to say indeed it points the other way. So my irrelevant was wrong. Irrelevant for their it doesn't assist their argument. I meant rather than
right.
I apologise, Lord. Your Lord is absolutely right to pick me up. It simply doesn't assist their argument because it is quite plain that there is no such obligation in EU legislation. And indeed, we say that points strongly in the opposite direction because it makes it all the less likely that Parliament was intending to impose such a duty, which I'll come on to. Secondly, at paragraph 34, they point out that Ex and Bedfordshire and Hague and other such cases didn't involve anything like the VAT system, which involves the statutory obligation to provide or obtain a VAT licence, being the way that the trader makes the claim for input VAT against the state. Now, that's not understood. If the point is that, well, this is a claim against the state, so you must take that into account when you're looking at whether there's a duty or not. This is, in a sense, the same as both Ex and Bedfordshire and Hague. They both involved asserted statutory duties, which would inevitably be asserted against public bodies, whether councils or local education authorities, the Secretary of State, for education cases, councils on the other cases. So they were all...
Sorry, why do you say that?
Because the duties asserted in Ex and Bedfordshire were...
Following Ex and Bedfordshire, but why in this case?
So, well,
it happens to be against Royal Mail, but it would be the same. I mean, Royal Mail is being treated for this purpose as a normal commercial trader, so it wouldn't matter whether it was Tesco or anybody.
That was one of the points I was going to make in response to this. It's simply not. It's my own friend who appears to be suggesting in his placing reliance in paragraph 34 on. I think the point made is that the statutory obligation to provide a VAT invoice is something which gives the commercial trader a weapon against the state. He can then, if there is a statutory duty to get his hands on it, then when he's got it, he can make a claim which will be a claim against the state for repayment. And that is in some way something which needs to be taken into account in considering whether there's a duty or not.
Yes, he's saying he needs this document in order to assert his right against the state, which he says is directly affected because of the directives, to claim back the input tax.
Indeed, and
so he has to assert a right against you in order to be able to assert his right against the state.
Oh yes, and what I think what is said is that that is relevant background here to consideration of whether the duty exists. Now, once it's absolutely true, but in Exton, Bedfordshire, and Hay, there were similarly cases of asserted statutory duties against the state, and if he's if he was making a point that when one looks at whether or not there's a statutory duty, one needs to look at whether, as it were, the individual needs to be armed against the state. Then it would apply to both. It may be a point that I can pass over because I'm picking up a paragraph in his skeleton argument that I'm not. It may be that I'm not interpreting the point that he wanted to make correctly. But we, of course, say that the VAT invoice is not a necessary part of the claim for input tax in any event against the state, both because the claim can be made without a VAT invoice, but also because of effectively the self-help remedy, the commercial reality, which is that a claimant, a trader can in any event effectively either require an invoice or refuse to pay without an invoice, and so on and so forth. Another difference is almost the opposite difference suggested by the claimants, differing in this case from Exton, Bedfordshire, is that the claimants don't seek here to impose actionable duties on public bodies, but on Royal Mail, which is, as was just pointed out a moment ago, purely a commercial trader. That again goes nowhere. The test applies both in, the statutory duty test will apply both in cases of duties against public bodies or in between private bodies. And an example of the latter is Todd and Adams, the fishing case, which I won't go back to, but that was a question of whether the fishing regulations imposed duties which would be actionable by individuals against ship owners based on the shipping regulations. That's simply an example of a case in the same category as this one. But we do say it's perhaps worth pausing on this point, the point made by the claimants, that what the court is here looking at is whether Parliament intended to create a private law cause of action by one commercial party against another. This is a case which has ramifications obviously far beyond postal services for all VAT traders seeking potentially to claim VAT invoices against any other trade throughout the whole system. It has far-reaching potential implications. And we say that, of course, Parliament wouldn't have intended any such private law right in circumstances where there's a statutory sanction, not providing a VAT invoice, where there's an alternative way of making the claim, and where there's the self-help remedy. But in addition to that, we do say that it's notable that despite the duties which this issue applies to, dating continuously all the way back to 1975, some 46 years, there has never been a decision establishing a private law cause of action for breach of the undoubted duty to provide a VAT invoice. If it was intended by Parliament as an important part of the smooth running of the VAT system, applicable not to some small limited class in this extreme case, but to all VAT traders, if it were in truth necessary or desirable, or conceived as necessary or desirable by Parliament, then one would have expected this issue to have been resolved long, long time ago. The fact that it is apparently the system has operated completely smoothly with the commissioners supervising the system over all the years without anyone having been driven to come to court to ask for a VAT invoice, we say is a pretty good indication now, and looking back in terms of what Parliament must have intended, that they wouldn't have viewed this as being as an actionable private law duty, as being a significant, important, or desirable, let alone necessary
Well, one can say that the present situation, the situation with which these proceedings are concerned, is extremely unusual. Or not?
Well, in some ways, of course, it's extremely unusual, the European Court intervention, but it's.
I mean, I don't mean the fact that people who, as it turns out, well, people who should be providing VAT invoices don't. That must happen from time to time, all along, for any number of different reasons, for insolvency reasons, lack of organisation, whatever.
Well, yes.
And maybe it's happened rather more during the last 18 months than it used to. And it's right to remember that the alleged duty could apply in much more ordinary situations than it is said to in the present situation. But the case of a party being found to be a taxable supplier rather than an exempt supplier, potentially for decades, retrospectively, when no one supposed that it was the case, that is highly unusual.
Well, it is, but that's not the statutory
therefore
duty.
Tests the point in a rather unusual way.
Well, it does. Two responses to that. First, one was looking at parliamentary intention. One is going to be looking at a much more generalised picture than the extreme facts that one can dream up years later. One is looking at whether it was seen as an important part of achieving a workable system of VAT administration between commercial trades generally. Secondly, although this case is born out of very unusual circumstances, as Lord has outlined, it doesn't follow that even in this case there is some crying out need for compulsion in the issue of VAT invoices, which is not being met. We would vigorously oppose that, and we're back to the zip litigation and the discretion which underlies that. The discretion of the commissioners to accept other evidence instead of a VAT invoice to make repayment, we say is absolutely integral. It's the strongest argument against there being an actionable duty between private traders, because it gives another effective path. Now, Mr. Cordara, relying on the fact of this case, says if it's a disaster, we're stopped because we can't show that VAT was paid. We're stopped from using that route, and he tried, indeed, at first instance, to extrapolate from that and saying the route is generally blocked. It's not just our case. Generally, unless you can show, which is extremely difficult, that's been paid, you can't get anywhere on that route. The judge, we say, absolutely rightly rejected that interpretation of Zipvit. What it was not saying was that you need to have shown that the person up the chain has paid the VAT before you can recover. It was saying, on the particular very unusual fact of this case, the claim is offensive to fiscal justice, is a claim which would be an uncovenanted bonus if it was allowed. In those circumstances, it was not only legitimate of HMRC not to exercise its discretion in favour of the taxpayer to accept alternative evidence, but absolutely that was the only decision which they could or should have come. The discretion either, I think Lord Henderson said, either the discretion didn't exist or it could only be exercised in one way, in my view, in this case. But that has no wider consequences in terms of the operation of the VAT system between traders. Obviously, whether Lord Justice Henderson is right or wrong, and the matter is still ongoing, whether or not the analysis of the Court of Appeal in that case is right or wrong, the fact is that it can be seen to turn on a very specific analysis of the specific factual affairs in this case, and therefore is of no use in trying to decide the question of whether Parliament intended there to be an actionable breach of statutory duty. Unless, provided that we are right, as we say we are, in rejecting the submission that the discretion is confined in all cases to a tiny, useless pool of case where you can prove that the VAT's been paid. We submit we're clearly right in that. That's not what Zipvit was saying. The case, the difficulties experienced by my learned friend, rightly or wrongly, whatever the ultimate outcome, we say don't assist in the argument there's an actionable duty. Can I then come on to the indications which we say collectively make it clear that, as the judge found, Parliament can't have intended to authorise private law claims on VAT suppliers to render VAT invoices. And I hope I can take these relatively shortly because they're clearly set out in our skeleton argument, and I'm sure, having seen the judgment in our skeletons, the court already has the point. In looking at all of these indications, we do remind ourselves and remind the court that, of course, the burden is on the appellants to establish that there are clear indications of what is an exceptional state of affairs. In other words, that a statutory duty gives rise to private law actionability. So the fact that in this case all the indications point in the opposite direction makes this, we say, a very clear case against actionability. And this is set out, the factors are set out in our skeleton at paragraphs 31 to 66. The first point is that there is no such requirement in the UK or European source legislation.
I take it you agree that the reason why the decision of in TNT applies, so to speak, retrospectively, is because of the leasing obligation to interpret domestic legislation conformably with EU law. Is that right?
My Lord, yes, and there is European authority to the effect that when, rather like with domestic courts, when the European court has pronounced on an issue,
that's what the
then
law
member states must give effect to that right back to the beginning, not prospectively from the date of judgment, but they have declared the law, just as the domestic courts declare the common law and find it to have existed, even occasionally at times when no one believed it did exist.
Though conveniently, sometimes they do arrogate to themselves the power to rule only prospectively,
Lord, yes.
except on the particular case before.
Lord, yeah, well, even in this jurisdiction, the difference between void and voidable, and some of these issues of media and indeed current legislative proposal to introduce that for the administrative court. But my Lord, that the answer to your Lordship's question is yes. That is, in this case at least, where we don't think that there's no indication of any prospective ruling. It is simply the ruling in TNT1 is
there are two parts to it, though, aren't there? Does the decision of the court, the European court, have retrospective effect on as regards what the directives mean? Answer yes.
Yes.
Second question, can domestic law be interpreted conformably with the directives according to the leasing principle? If the answer is yes, then it should be. If the answer is no, then it's got to be disapplied.
Well, I would accept, I don't think we've ever taken the point that the leasing principle has to be applied according to the state of the law as it has been found by
yes,
the
and it's because of leasing that the VAT Act, before its amendment, was to be construed in accordance with TNT.
Lord, yes, that must be right. Well, it is the case, and in answer to a question of your Lordships, it is absolutely the case that there continues to be significant disagreement as to what the European test means in TNT1 and which services it applies to. That was already worked out to some considerable degree in TNT2, the Whistle case, by Mr. Justice Kenneth Parker, where there were at stake there certain services called access services, where TNT, who was at that stage still prosecuting its campaign to become an end-to-end provider in competition to Royal Mail, sought to say that those services fell within the scope of the judgment and therefore should never have been vatable. And Royal Mail said, no, they are within the penumbra of the universal service and are therefore within the confines of that judgment. They remain exempt. Royal Mail succeeded in its argument on that case, on Whistle 1, and the issue was appealed to the Court of Appeal, but TNT then abandoned its appeal before that matter reached this court. So that was the only judicial skirmish that there has been, more than a skirmish, the determination since TNT1 in this jurisdiction as to what the judgment means when it talks about the public postal services acting as such and other slightly obscure terms used in the judgment. But there remains in this litigation a considerable argument to be had about whether some of the services of which, in respect to which the claimants claim, are indeed actually vatable or not at all. So, Lord, we note at paragraph 32, where we say the judge rightly noted the absence of any requirement for an actionable statutory duty in the source legislation at European and UK levels. We say it's clear that EU law did and doesn't require member states to provide a domestic remedy for failure to provide a VAT invoice, let alone render it actionable damages. The relevant EU duties which you've seen, and I don't need to go back to, simply require member states to ensure that every taxable person shall issue an invoice in respect of all goods and services supplied by him to another person. And that, both in the 6th Directive and in the Principal VAT Directive. No provision in those directives, i.e. no requirement on member states to provide for any claim in damages by one taxable person against another taxable person for failure to provide such an invoice. No stipulation as to any particular enforcement provisions relating to the obligation to provide a VAT invoice. We submit in the light of this, it's clear that the intention of the domestic legislation is simply to implement the EU obligation. There's no indication of the possibility which Lord Justice Lloyd referred to, and which I accept is in principle possible. There's no indication of the domestic legislation intending to go further than that European position by making the duty actionable. On the contrary, the opposite. What the domestic regulations did was to back it by a civil penalty and back it by the other indications that I will rely on. I think it was said by my learned friend that, well, you'd never find a duty you'd never find a provision in a directive requiring member states to give a damages remedy. In any event, you would be wrong to find it. I'm sure that's not right. And indeed, there's a case that we've cited in this case.
I think there are various intellectual property enforcement directives which do require remedies.
And public contract regulations. Yeah. It all comes to mind. There's a judgment of Lord Mann in a case that we cited in this.
Nuclear decommissioning.
Energy solutions. In this very case is an example of the European statute. Rather than searching for it now, I could perhaps dig it out overnight. It's a perfect example of the directive saying to member states, you must impose a damages remedy here. And the argument that went all the way up to the Supreme Court was when it said damages here, and the domestic legislation faithfully copied that out. There was damages remedy. And then there was an argument, did that mean Frankovich damages, which is all that the European obligation required, or did it mean full damages? And Lord Mann said, well, you presume that the UK legislator is not going further than the EU requirement, and therefore it only means Frankovich damages in the domestic statute.
Yeah. I think in intellectual property there are also directives which require remedies to be proportionate and effective remedies.
Indeed. Well, that is Lord, yes. But in this case, it goes so far as to actually specify damages, and that is for your lordship's note. I'm not going to go to the bundle now, but it's in the third authorities bundle, tab 7.
Now, can I just ask you about paragraph 39 in your skeleton? I mean, I assume that you drafted the skeleton before the duty incorporated the section 69(8) defence of reasonable excuse. Would that satisfy Frankovich criteria? I mean, in order to have a Frankovich claim, you, in effect, mustn't have a reasonable excuse for not complying with EU law. I'm just wondering how the recasting of the duty affects the interaction with Frankovich. Perhaps I'm not making the point clear enough, but do you see what I mean?
I'm just thinking that through. So this passage is pointing out the ability to claim damages, breach of EU law, is of course contingent on the Frankovich criteria. Lord, yes. So
at a time when he was saying
yes,
30 days, you're in breach, you were saying, well, that's not very likely because EU law, when EU law does give you a remedy, it's a sort of Frankovich type. It depends on the satisfaction of the Frankovich criteria or conditions. Mr. Cordara now says, oh, well, built into my duty is reasonable excuse. If there's a reasonable excuse, there's no breach. So it might be said, well, Frankovich is satisfied once you've built in the reasonable excuse to the duty.
yes. Look, the reason I wasn't developing that point is I'm not sure Frankovich is relevant to this stage of the argument, because we're talking potentially about a duty applying to private commercial traders, as
indeed.
Royal Mail is for these.
Yes, I follow. But in the energy case, what wasn't Lord Mance talking about?
Yes.
Frankovich
Yes.
conditions applicable to claims between citizens. If I can.
He was construing the
Procurement
regulations to understand whether in the domestic regulations, when they referred to damages and a right of damages for various breaches between tenderers and persons submitting to tenderers and persons letting contracts, whether or not that requirement of damages meant Frankovich damages or meant normal domestic damages. And he looked back at the empowering the European legislation, which said where damages clearly meant Frankovich damages. And he said, well, and he simply said, well, that colours the interpretation of the word of the domestic statute. And although obviously we normally read it in domestic statute damages to mean damages, in this situation it means Frankovich damages. Yeah. Now, I'm not sure that excursus particularly assists here. My point was rather that there is nothing in the EU legislation that creates an obligation to give a damages remedy at all. Frankovich damages or any sort of damages. There's nothing at all. It's just completely silent. And worse than that, from a local defence case, it leaves open to member states the full range of enforcement to enforce the obligation to provide a VAT invoice. So far from there being anything that one can extract from the European legislation that might assist in construing the domestic legislation as requiring an actionable duty, it does the opposite. Because what was quite plain is that Parliament was effectively, through the regulations, via Parliament into the regulations, it was effectively a working through of a discharge of the obligations in the directive, and therefore one naturally, just as in the Energy Solutions case, one naturally carries it through in the same way, unless there's some indication, specific indication of some different intention, which there wasn't there and there wasn't here. And that is precisely the point which I then make in the Energy Solutions case. Yeah. Well, for your Lordship, it's paragraphs 39 and 37, the judgment of Lord Mance, where he deals with this point and concludes at 39 that the correct interpretation of domestic law is to go no further than the EU law which it implemented, and damages therefore only meant damages upon satisfaction of the Frankovich criteria. Now, the way my learned friend has reformulated the issue, I'm not sure makes a difference. If there was a duty, if there was a breach, one would still have to go through the Frankovich criteria, and one would reasonably excuse would be one part of that. But Frankovich criteria potentially even higher than reasonable excuse. It could be a manifest breach, and so on and so forth. But that's not even. It's not even such a duty which is imposed here. There's no duty at all, no Frankovich duty, let alone a domestic actionable statutory duty. And the claimant is in no better position if one considers the UK legislation, aside from the EU context. that there is authority that, in order to be actionable, Parliament, in enacting the primary legislation, authorised the minister to create private rights for the benefit of individual claimants. That is Clark and Linsell, paragraph 945. We cited it in the skeleton. I'm not going to take the court to it. In a sense, that's obvious. Otherwise, the secondary legislation would be likely to be ultra vires. But I'm not going to push that point any further, because here one has, as it were, the tripartite EU primary legislation and secondary legislation situation, where the primary legislation is effectively a conduit. And therefore, although one is still looking for parliamentary intention, and that has to be the touchstone in looking for an actionable statutory duty, one is looking at parliamentary intention in terms of what did the EU legislation require, what did the regulations effectively say. And since we're not arguing that the regulations are ultra vires, maybe it doesn't take one much further. But we do say it is significant that there's nothing in the primary legislation that Learned Friend can point to, or has pointed to. Nothing to suggest that actionability was intended.
Yes, except that your paragraph 42 starts considering the UK legislation aside from the EU context. So,
well, I was merely,
I mean,
yes.
You're tying them back in together again, and effectively coming back to the point. Well, you can't assume Parliament meant to go further than the EU obligations require.
I think when I said aside from, I was saying, well, we've looked at the EU, we've seen no indications there.
Yeah.
It's really Lord Justice Timothy Lloyd's point is that well, you could still have an intention,
yes,
which is evident in domestic legislation, not in the EU. It could have been gold-plated in that
way. Yeah, well, then your point about subordinate legislation might come into play. There is no obligation in EU law to create a cause of action in damages. Yes. Parliament doesn't expressly create one in the primary legislation.
Yes.
Is there one created by the secondary legislation?
It couldn't be. The answer at that point would be, well, where is the virus to create an actionable statutory duty? HMRC effectively creating an actionable statutory duty off its own bat if it's not indicated in either primary or EU legislation. And we say for that reason as well, the court ought to lean against any such interpretation of the regulations, because they would give us that very serious question: where does this come from?
Yeah.
My lady, my lord, the second indication is the sanction prescribed for not issuing a VAT licence. And we do say that this is a significant indication. The specified powers of enforcement, as the judge put it in paragraph 96, which HMRC can deploy in the event of a default by the trader. I'm not going to go through the mechanics of those provisions, because they're set out clearly in the judgment and they're not effectively in dispute. The judge... sorry, I lost my judgment. Yes, so the judge concluded at paragraph 85 that the net effect of the provisions is that the failure to provide a single VAT invoice attracts a maximum penalty between 1,500 and 1,500, depending upon the previous record, subject to the reasonable excuse provision. That's a single VAT invoice. Given the number of invoices potentially involved in this case over many, many years, the penalty wouldn't perhaps be so significant, so insignificant overall. But we submit that in response to the appellant's argument that the weakness of Section 69 is such that it shouldn't be understood as a sanction within the meaning of what was intended by Lord Brown Wilkinson in Exon, Bedfordshire. We do say that I mean, the judge rightly noted the lack of strength of it as an enforcement mechanism. He said it has to be acknowledged, paragraph 103, but Parliament put it there, and it's the existence of some power of enforcement which is more significant than what one might think about its effectiveness. Now, we respectfully say that was the right way to view the power. One must bear in mind that this is a civil penalty being imposed on taxable traders, VAT traders, and the potential for the revenue to be picking up the phone to you and asking about why you haven't given an invoice and threatening to impose a civil penalty, even one of relatively modest amounts, is self-evidently a very significant spur on VAT traders. If one was serially not providing invoices, one knows very quickly where that can lead to in terms of the attention from HMRC in terms of one's VAT systems. It is the specific breach of duty in respect of which it sought to be made actionable, which is sanctioned in the legislation, provision empowering HMRC to act, and HMRC being, of course, the relevant regulatory body supervising the operation of the system. And the judge also rightly had regard to how the revenue operates. The system, you've seen his reference to the 2016 VAT Traders Records Manual, paragraph 99, which addresses the problem of the trader's delay or failure to provide the invoice, and suggests there that the ultimate remedy is the threat of a civil penalty, with no suggestion whatsoever of a private law right being even in the picture. Now, of course, the judge rightly noted at paragraph 100 that that's not a legal argument, it's just the revenue's view. They could have got it wrong, they could have not known about a civil penalty. But it is an indication of HMRC's view that the system's properly workable without a civil law remedy being open to the customer. And then one has the discretion as to the content of the duty and the time for compliance. The judge rightly, we say, placed weight on the fact that HMRC does have a discretion as to the content of the duty to provide the VAT invoice, and further as to the time by which the invoice should be provided, as pointing against a duty actionable damages.
Is it a question of discretion? I wonder, just in view of some of the EU cases that are in our bundle, where they stress the importance of the right to deduct, and they say, I thought, that if the taxing authority has all the necessary information, it must allow the deduction,
Well,
even though there's no invoice. It's not a question of discretion.
Oh, Lord, absolutely.
The right to deduct, so to speak, overrides the lack of the invoice where the taxing authority have all the necessary information.
Well, yes, I wasn't talking about that discretion. I was talking about the anterior discretion as to what actually has to be in the invoice. And when the invoice has to be provided. It's absolutely right that there is it's not purely a discretion if they feel like it. There's a mandatory obligation not to set the magic piece of paper in the way of a proper claim for repayment, which is yet another reason why one doesn't need to look for actionable statutory duties to compel the magic piece of paper. But there's a separate point, which is that, and this is really the Todd and Adams point, which is that if the very duty which you are asserting forms an actionable statutory duty is not actually something which is clear and fixed and unchangeable for all cases, but can itself be changed at the discretion of a third party.
Well, Mr. Cordaro would say that Article 222 tells you the minimum requirements for an invoice.
It does,
and that can't be changed.
Well, what can be changed is the timing. Because you can delay the thing, so you can actually not have to provide it when you at the 30-day period. So a claim which we were about to make suddenly has moved off because the revenue said, fine, you've got a big problem, you've got a fire at your office, whatever it is, we'll give you another 3 months or so. Maybe all sorts of circumstances in which they can change the date, but the very thing that makes it actionable at a particular time can be changed at the revenue's behest. And there were also significant changes, which I'm not going to go through the detail of, as discretion to relax the timing was noted at paragraph 83 of the judgment, and in addition, there are, it's not just the details of what's in the duty. The judge made the point that there appeared to be in at least some of the forms of regulations, there was in some of the forms of regulations, as to whether there was any requirement to provide a VAT invoice at all on the language of certain of the versions of the regulations. And if one looks at paragraph, I was slightly chastised for not making enough of this, but if one sees paragraph 81 of His Lordship's judgment, Justice Mann's judgment, one sees that the intervening regulations, the 77, 80 and 85 regulations, contain the wording in regulation 8.1, save as otherwise provided for in these regulations, or as the commissioners may otherwise allow, a registered taxable person making a taxable supply to a taxable person shall provide him with a tax invoice. And regulation 12, that's 12 of the 85 ones, 81 of the 77 and 80 regulations. Those italicized words disappeared from the 1995 regulations. Mr. Herberg did not seek to make as much about the presence of those words where they occurred, but I do not think one can ignore them. Well, I did draw them to his lordship's attention and put them forward. No one suggested that any statutory duty has varied over time, so one has to give them the same effect across the period. If one were considering just those earlier regulations with the emphasized wording in, it would probably be more significant indication of intention than Mr. Herberg's other examples. My other examples were variations as to what ought to be in them at invoices or the timing point. And he's making the point, well, actually, these regulations actually give the Commission the power to say, you don't have to provide one at all in these circumstances. No doubt thinking we can deal with any claims for repayment by our discretion. And that is a strong indication against attaching an actionable statutory duty to the obligation. And that is all in the context of Todd and Adams and Cope, the Trelawney Fishing Company case. I don't think I need to take your lordships back to that. The judge has addressed it in his judgment at paragraph 86, and he quotes, we say rightly from paragraph 25 of the judgment, where the court relied on the fact that the Act gave the Secretary of State a power of very wide and flexible nature to exempt vessels from the ambit of any rules, tends to support the proposition that there was no intention to impose a civil liability for breach of any of the rules.
Yeah.
We say, learned friends seek to say that these powers to vary content and timing are not so significant that they don't go to the underlying obligation, but matters incidental to or descriptive of it. One response is, well, they do go further than that, as the judge pointed out. They actually go in at least 3 sets of the regulations, at least 3 sets, to relief from the obligation at all. But in addition, we do say that it is antithetical or an antithetical indication. It's not rule it out in itself, but is an antithetical indication to actionability. To have a power which is dependent on a duty which is dependent on the exercise of discretion by a third party. In principle, that the revenue could presumably take action even after the duty was said to exist. I mean, if after 31 days I approach the revenue, I approach the commissioners and say, can you please relieve me of this obligation to provide a VAT invoice? I've had a terrible fire, for example. And they say, after a little bit of consideration and back and forth, fine. It might, or in Friend's case, as it were, vaporize the duty after he claims it has actually arisen, the actionable duty after he claims it has arisen. Then the fourth point is alternative and sufficient remedy. And we do rely very heavily on this point because we say it's a very strong indicator against an actionable duty. The judge agreed, there is an alternative and sufficient method of obtaining input tax, an alternative remedy provided within the statutory scheme to accommodate any individual affected by the failure by a taxable supplier to provide a VAT invoice. This is the discretion given to HMRC to accept alternative evidence instead of a VAT invoice. And the discretion is found, your lordship's already seen it, so I won't go back to it, in proviso to regulation 29.2 of the 1995 regulations, quoted in the judgment at paragraph 40. And it's worth noting, I might just ask you to look again at the wording of in paragraph 40 of the judgment, the proviso, because it gives, what is clear is that it gives the commissioner the discretion either for a class of case, right, where the commissioner so direct, either generally or in relation to particular cases or classes of cases, the claimant shall hold or provide such other evidence of charge to VAT as the commissioners may direct. So we say that there's a very wide discretion. It's either for a class of case where there's need for alternative evidence to a VAT invoice in a systemic way, or in an individual case where a VAT invoice is not available. In either of those, they can direct that a claimant can hold. That might suit a prospective ruling, or likely for a class perhaps, or provide. That would meet the justice of an individual case where a claimant comes along and says, "I can't do it. Can I do something else?" Yes, you can provide something else. Such other evidence as HMRC may direct. And the judge noted in paragraph 103 that this alternative method was acknowledged even by the appellants as of real significance. We say rightly so. The judge at paragraphs 87 to 95 considered and rightly rejected the submissions that there was, in effect, no alternative to producing an invoice. He considered that it was a real alternative. It was, in his words at paragraph 95, at the end of his consideration, a workable scheme embodying discretions which points away from there being a statutory duty to provide an invoice. Well, it's important to note, Lord and Lady, that this relief provision has its genesis in the EU directives. It's not simply something which the revenue has dreamed up. So to the extent we are reaching back to look to assess actionability according to the European background, the EU directives expressly permit member states to allow deduction of VAT even where no VAT invoice has been provided. Lord, I don't think these this is quoted in the judgment. It might just be that I should show it to your lordships.
This is Article 180, is it?
No. Yes, it is Article 180. It is.
We looked at that this morning.
You did look at. I apologise. You looked at. I was looking at the prior. I was looking at Article 18.3 of the 6th Directive, but that's in similar one. You were shown Article 180 of the Principal Directive. That may authorise a taxable person to make a deduction which he has not made in accordance with Articles 178 and 179. And there's a proceeding power. It perhaps goes even further in Article 18.3. I'll just read it to you of the 6th Directive. Member states shall determine the conditions and procedures whereby a taxable person may be authorised to make a deduction which he has not made in accordance with the provisions of paragraphs 1 and paragraph 2.
Which article is that?
That's Article 18.3 of the 6th Directive, Bundle 2, tab 39, page 129. Perhaps in even stronger language. So paragraphs 1 and 2 are the paragraphs saying you need to have a VAT invoice. And Article 18.3 is mandating member states to determine conditions and procedures whereby the taxable person can be authorised to make a deduction which he has not made in accordance with the provisions requiring him to have a VAT invoice. So it's not even an option there, it's a duty, it's a European duty. That's part of the European scheme which the UK then transposed through, expressly contemplating the deduction of input tax, absence of that invoice, and mandating member states to determine conditions and procedures to this. Now, Lord, the claimants submit that that remedy is inadequate because HMRC has declined to exercise its discretion to allow them to deduct in the ZIPFIT legislation. So ZIPFIT becomes very important to trying to stultify this wide discretion. Well, there are two broad answers. One is they've misinterpreted ZIPFIT. It doesn't have that wide effect. It's much more limited to the particular circumstances of this claim. It doesn't say anything. It doesn't impair or hinder the exercise of the discretion in any normal case. And the second point is that even if it could be construed as having that effect, it can't be construed to have that effect because under European law, you wouldn't be able to stultify the mandatory duty in that way. There must be an effective remedy, and it therefore can't be interpreted as standing in the way. And it's quite plain that Lord Justice Henderson and the Court, we say we're not seeking to impose any such.
Well, if we're going to go on to ZipFit, shall we do that tomorrow?
It may be a good moment to pause.
Yes. Just remind me, would you, in which bundle is ZipFit? Because I think it might
ZipFit
be
is in,
if I read it overnight.
Yes. Well, yes, it is in tab 2 of, I think it's bundle 3.
Bundle 3?
Yes, bundle 3, tab 2.
Yeah, thank you very much.
I'm told the Supreme Court is in Volume 5. Which I must confess I haven't seen myself, but it obviously isn't a substantive judgment.
Yeah. Right. Thank you all very much. 10:30 tomorrow morning. I should have said, I don't know if I did, that we would like the transcripts, please.
Splendid. 4 pages to a page.
Yes, fine.
All rise.